Court is calling 2022 CR 10641, State of Texas versus Wayne Toiver. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Jason Goss for Mr. Toiver.
All right. So, are you Mr. Toiver?
Yes, ma'am.
This case might sound straightforward, a guilty plea with a 5-year sentence on the table. But don't blink. What unfolds here is far more complex than just guilty or not. We've got a defendant with a decades-long history of battling alcohol, a defense team fighting to frame his relapse as a one-time slip, and a judge who refuses to let DWI cases slide. The question isn't just how much time Wayne Toiver will serve, but whether he'll ever break the cycle. Stay with me, because the twists ahead reveal a justice system trying to balance punishment with rehabilitation.
All right, you entered a plea of guilty on March 23rd. According to the plea bargaining agreement, the state and the defense both have now agreed to your punishment be assessed at 5 years in the prison, and there are no applications. Do you understand that to be the new plea bargaining agreement?
Yes, ma'am.
Are you asking the court to follow that agreement?
Yes, ma'am.
Defense state, is that the agreement?
It is, Your Honor.
Yes, Your Honor.
And I believe there was a PSI that was tendered in this case. Have both parties had a chance to review the PSI?
Yes, Your Honor.
Yes, Your Honor.
Any objections to the PSI, state or defense?
No, Your Honor.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor. Just that, as you can see from the PSI, my client has had his struggles with alcohol, but he did go to the penitentiary for the last time 20 years ago. And so he was sober for 20 years. He has been working in the same place for 40 years, almost 40 years, as a forklift operator. He has family here. He has his siblings here who support him. He has his wife that he has been with for the last 20 years, also here to support him. And we're just hoping that this will be the last relapse and the last time so that he can come out and provide for his family.
To go around.
Oh,
He needs to sign that.
this is just saying that you don't have a right to the relapse. She calls them. So they're just asking for something. Thank you, Your Honor.
All right, and I'm sorry, Counselor, you were.
Notice how the defense leans heavily on Wayne's long sobriety streak and decades of steady work. It's an attempt to humanize him, to argue that this one relapse shouldn't erase 20 years of progress. But here's the problem: in DWI law, intent doesn't matter. Whether you meant to or not, operating a vehicle under the influence endangers lives. The judge and the state aren't here to measure the good versus bad years. They're here to ensure public safety. Question for you: should a relapse this serious be forgiven as a bad night? Or is that exactly what makes it too dangerous to excuse?
Making remarks?
Yes, Your Honor. And I guess to sum up that, he has lived a life well since the last time that he came out of prison, but he did have a relapse. The facts of this case were that he was asleep in his car that was in a parking garage. The car was on. We weren't contesting operation. That's why we have done the plea, because we've explained that to him. And he had a bad night. He had a bad moment, in 20 years of his life. And so he understands that he's got to pay for that, but we're just hoping that he can go and come out as soon as possible.
Okay. Is there a reason there's no recommendation for probation on this case?
Just for a previous record, Your Honor.
All right. So, Mr. Toiver, I'm going to give you an option. And it's because I'm reading the plea paperwork and I know you have a lot of DWIs. And I'm a firm believer that there are many things. In this case, there's no accident. You're asleep behind the wheel. You can either go to safety and be on probation. Safety is treatment. It's a long term of treatment. There's a waiting time. Or either I can sentence you to prison. Which would you prefer?
Your Honor, may I speak on briefly? Your Honor, he'll choose safety.
And I know, state and the,
Here's where things get really interesting. The judge isn't just rubber stamping the plea deal. Instead, she dangles two starkly different paths. 5 years in prison or probation through a long-term treatment program called safety. It's a moment that exposes the larger dilemma. Do we punish repeat offenders with prison time or invest in rehabilitation to break the cycle? This isn't just about Wayne Toiver. It's about a justice system caught between retribution and recovery. Imagine being in Wayne's shoes. Would you take years behind bars or gamble on a grueling rehab program that might be your last shot at freedom?
according to the plea bargain agreement, you all were remaining silent.
Oh, yeah.
So, well, in the original plea bargain agreement, you were silent, and then you all changed to 5 years prison.
Yes, sir.
So,
I believe.
well, no, actually, it wasn't a solemn, it was just a, I'm sorry,
Yeah,
it was
yeah.
just a cap of 6 years. So,
But our argument would be the same, Your Honor.
all right. So do you have any objections, State, to the court making Mr. Toiver the offer of going in inpatient treatment?
We will not oppose that.
All right. So you're going to be taken into custody today. I'm going to want him in inpatient treatment. And inpatient treatment at safety. If felony drug court determines they have an opening for him, because part of the reason the felony drug court didn't accept him was because of the fact that they were at capacity. I know they're having a graduation coming up, so they won't be at capacity. And the other reason is they were saying that they think he may be in remission or whatever. But he can be re-referred to felony drug court, but he's going to remain in custody until either he's accepted in felony drug court or either he's going to safety.
Yes, Your Honor.
All right, so, and is there any objection to going back to the original plea bargain agreement, which was the cap of 6 opposed? The cap of 6 with no application.
There is no objection to going back to that, obviously.
So the court is going to sentence you to 6 years in the prison, suspended and probated for 8 years, DWI intervention, DWI education, VIP live. There's to be no driving for the length of probation, regular reporting by Zoom or in person, regular UAs, 2-year driver's license suspension. He is to provide an affidavit of non-driving, but there's going to be ignition interlock on any vehicle that is, at your home, but you're not allowed to drive.
Pay close attention here. The judge is stacking condition after condition on Wayne's probation: ignition interlock, no driving, drug court referrals, field visits, mandatory employment, and even restrictions on what kind of job he can hold. This isn't leniency, it's control. The message is clear. Wayne's freedom comes with a cage of rules, and one slip could slam the prison doors shut. It's a fascinating example of how modern sentencing often blends mercy with surveillance. Question for you: is this layered probation a fair chance at rehabilitation, or just a slower, more stressful path back to prison?
And I'm going to want him on a portable device then. And I'm going to want field visits 1 time per month for 3 months upon release. And probation, if you feel there's no need after that, then you all can do it by randomly or however you feel is needed. I've already said a referral to felony drug court. I'm going to order safety. It needs to be remain in custody. Proof of employment. within 30 days of release. There's to be no employment as a home health care provider with minors. And regular UAs. Is there anything else, probation?
No, Your Honor.
Is there anything else you need from the court to be successful?
No, ma'am. Thank you.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we're off the record. I take DWIs very seriously. People can get killed. But I do think that just sending someone to prison sometimes and then having them come out, they're going to come out with the same issue. You need to stay hyper vigilant. You cannot drink alcohol at all. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.